The Role of Hadith in Ikhtilāf among Muslim Jurists by Musaed Salem Abdulkader. Rejecting Ahad Hadith pertaining to widespread habits and matters. While most scholars do not reject such hadith, the Hanafis in fact do, on the grounds that widespread matters should provoke and lead to lots of queries and questions being raised by people, and hence pertinent hadith should be mashhur, if not mutawatir. Shirazi, however, refuted this, saying that a large number of questions and answers on such issues do not necessarily lead to a concurrence of the reports, because the causes of reporting a hadith vary and depend upon many circumstances. On such grounds, we can explain the fact that although the Prophet performed the pilgrimage amidst tens of thousands of companions, a very small number has ever been reported to describe the rituals and pillars of the pilgrimage. Ibn Hazm, in his defense of the majority's position, said, "Religion as a whole is a matter which is widespread, and the need for it is also general, one that people need to learn." I, however, find Ibn Hazm's argument too broad and engulfing, for there are indeed many areas and fields of the Shari'ah which most laymen never acquire the need to learn, such as matters pertaining to shura, war laws, juridical matters, etc. Nevertheless, I adopt the position of the majority for the argument presented by Shirazi. The Hanafis, it should be noted, were not consistent when they accepted Aisha's hadith, which purports that ablution is invalidated by nose bleeding or burping or vomiting. And when they accepted Juhani's hadith purporting the invalidation of ablution for laughing during prayers, though clearly such matters occur daily and are very widespread. It should also be mentioned that even the companions accepted Ahad hadith pertaining to such matters when they were upheld. Aisha's hadith enjoining bathing after any intercourse, even though they believed that earlier ghusl was compulsory only after ejaculation. It is clear that such matters are most common and widespread in all places and times. The effects of this constraint upon Ahad hadith for the faqihs was apparent in the following instances amongst others. 1. Many scholars hold that ablution is invalidated by simply touching the penis, whereas Malik held that pleasure must accompany the touching for invalidation to take place. This decree was based upon Busra's hadith, "He whoever touches his penis may not pray before performing the ablution," collected by Ahmed. The Hanafis rejected this hadith, chiefly on the ground that such matters were too widespread to be narrated only by one woman. They also substantiated their claim by Qais's hadith, which says, "It is part of your body and you should not be bothered." The majority of the scholars hold that the latter hadith is abrogated by the former, and that the former was indeed also narrated by more than 10 other companions besides Busra. 2. Most scholars hold that one should raise his hands in prayer immediately prior to and after the prostration, because this was done by the Prophet in his prayers, as reported by Ibn Umar in Bukhari and Muslim. Abu Hanifa held that this action of the Prophet should have been reported by many other companions, since he performed 5 daily prayers daily in front of them for many years. 3. Rejecting hadith which are not observed by the narrators. The Hanafis hold that since the companions strictly observed and abided by the teachings of the Prophet, the correct explanation of a case where a companion did not observe the hadith which he himself was narrating is that either he knew that it was abrogated, or that its correct interpretation was more subtle than it was initially apparent, and so such hadith are not binding. The Hanafis, however, qualified this by stating that if the action of the narrating companion departed from the narration prior to the reporting of the hadith, then the upheld hadith in favour of the companion's action, and vice versa. Hajawi reports that Abu Hanifa was in line with Sa'id ibn Musayyib in this matter, for Sa'id rejected Ma'mar's hadith that profiteering is disdainful, because Ma'mar, the narrator, used to monopolize on goods. Karhi, from among the Hanafis, along with the other madhabs, believed otherwise, explaining that the companion may have forgotten his narration, or that he incorrectly interrupted and understood it, or that he believed the mitigating circumstances allowed his departure from his narration, etc. The scholars also went on to say that it is even possible that the companion knowingly, without any reason, just did not observe his hadith, though this would not undermine his trustworthiness, and so he must also abide by the overt and apparent meaning of a hadith. Ibn Hazm was reported that the Malikis in such cases reject the hadith and abide by the deeds of the narrating companion. Commenting on this position, he says, the Malikis were inconsistent in this matter, for they accepted Abu Hurairah's hadith that dishes should be washed 7 times if licked by a dog, though Abu Hurairah did not abide by this narration. This position has been attributed to the Malikis by others besides Ibn Hazm, such as Khafif and Shawkani. Among the effects this constraint had on the following implication for faqihs. 1. Being consistent with their position, the Hanafis did not abide by Abu Hurairah's above-mentioned hadiths, since it is not known that Abu Hurairah washed those dishes only 3 times. The other madhabs, scholars, however, upheld Abu Hurairah's hadith and cited another narration which showed that Abu Hurairah did wash those dishes 7 times. The Hanafis also rejected Aisha's hadith, describing as void all marriage contracts enacted within the consent of the female's guardian or sponsor, because Aisha herself wedded her niece Hafsa to Abdurrahman, even though her guardian, namely her father, was far away in Levant. The 3 other madhabs, however, considered Aisha's hadith as binding and unaffected by her actions. Abu Hanifa's student Ash-Shaybani, however, reconciled Aisha's hadith with her actions by commenting that if the absent guardian consents to the wedding performed in his absence, then the contract remains valid and binding. Rejecting ahad hadith forgotten by their narrators. There is a consensus among scholars that if a companion belied a person attributing a hadith to him and remarked that he had never even narrated the hadith in question, then the hadith is abandoned and rejected unanimously. The scholars have, however, disputed as to what should be done if a companion simply says that he does not remember narrating a hadith attributed to him. The Hanafis hold that such a hadith is not binding and is invalid, whereas other scholars, including Ash-Shaybani, have upheld those hadith and abided by them. Imam Ahmad ibn Hanbal sometimes, it was said to have rejected hadith as reported in Kashf al-Asrar, whereas Amidi has reported that Ahmad's position was in line with the majority of the scholars, and this latter viewpoint is substantiated by a narration of Ahmad reported in Al-Madkhal. Al-Khatib al-Baghdadi also reported narrations substantiating the latter's claim, without mentioning that a contrary narration also exists. Turki, in his Usul Madhab Ahmed, did not even touch upon this subject matter at all. The effect of this dispute was that, 1. In resolving disputes in court, Abu Hurairah's hadith that the Prophet had resolved a dispute after the testimony of only one witness, under an oath of truth, is rejected by the Hanafis because one of its narrators, namely Suhail ibn Salih, forgot it, and then narrated that Rabi'a attributed to him this hadith without accusing him of lying. The other 3 madhabs, however, abided by this hadith, which is also narrated by Muslim, and others with some variation in details. 2. Again referring to Aisha's early hadith of marriage without the guardian's consent, the Hanafis, in rejecting the hadith, pointed out that Zuhri, a narrator of the hadith, could not recall reporting it. The other 3 madhabs, in line with their standpoints, accepted the hadith and considered it binding. Number 5. Rejecting hadith pertaining to penalties. The Hanafis reject such hadith on the grounds that the ahad hadith are never free of some obscurity and suspicion, and we are ordained to ward off penalties when obscurities arise. The other madhabs, including the Hanafis Abu Yusuf and Al-Jassas, upheld those ahadith and considered them binding. The majority of jurists have argued that there is no special reason to distinguish between authentic ahad hadith with different subject matters. They also pointed out that the penalties are inflicted by courts of law on the evidence of witnesses, even though the people delivering those witnesses could be lying. The effect of this dispute was that, 1. The Hanafis refuted Abu Hurairah's and Zayd ibn Thabit's hadith ordaining the banishment of the unmarried fornicator, on the grounds that the Quran only enjoins flogging him without banning him for a year. This hadith is narrated by the 6 most prominent books of hadith and is upheld by the other 3 madhabs. 6. Rejecting ahad hadith in conflict with Medinan Amal, Amlu Ahl al-Madina. Malik was among all 4 madhabs in imposing this constraint upon the validity of ahad hadith. This asal, this basis, namely Amal Ahl al-Madina, the actions of the Ahl al-Madina, is greatly revered by Malik and is held to overrule Qiyas and Ahad Hadith. Some Malikis, however, were too hasty in not noting that Malik always upheld authentic Ahad Hadith if they were not incompatible with the Amal of Ahl al-Madinah. This is understood from Iyad's comments, and some have attributed to us Malikis that we reject all Ahad Hadith unless supported by Medinan Amal, failing to distinguish our rule position, which is that we reject Ahad Hadith only when they are irreconcilable with Medinan Amal, not if they are simply not supported by the latter. This understanding of Iyad is further supported by the fact that there are many ahadith in Malik's Muwatta which are not in conflict with prevailing Medinan Amal, which were also upheld by Malik, such as the hadith prohibiting asking the price of a dog, or the hadith prohibiting the slaughtering or the slaughter animal of the ha'id before the Imam completes the sermon. That means the sacrifices. Malik considered Medinan Amal to be applicable on 3 levels, which I will mention in descending order. The first, Medinan consensus which no one disputes, even from among non-Medinans. 2. Medinan consensus which some disputing from among non-Medinans. Malik refers to the latter 2 levels as the categorically authentic and valid Sunnah. 3. Matters in which Medinans themselves did not or could not arrive at a consensus. The other madhabs disagreed with the Malikis in this, regarding the most prominent amongst them being Shafi'i, who was once a student of Malik. Shafi'i expressed disagreement with Malik in a book entitled Ikhtilāf Malik wa Shafi'i. Similarly, Abu Hasan al-Shaybani in his Al-Hujjah al-Ahl al-Madinah, authoritative disproof of Ahl al-Madinah, disagreed with Malik and Al-Layth ibn Sa'ad in a letter sent to Malik in which he argued against Malik's views on some matter. The majority of the jurists disagree with the Malikis vis-a-vis Amal Ahl al-Madinah. They argue that overruling a Sunnah not known by the Medinans by the actions of the people of Medina is unjustifiable, because it was just possible that many Sunnahs of the Prophet might have escaped the attention of the Medinans, since most of the companions of the Prophet had migrated to new places conquered by the Muslims. This fact was supported by citing many ahadith of the Prophet which were narrated by Ibn Mas'ud and Mu'adh ibn Jabal and other companions who were known to be living away from Medina and which the Medinans were unaware of. The effect of this dispute was that 1. Malikis, unlike others, did not accept on the grounds of the given constraint Abu Umama's hadith that the mother's brother inherits when there was no other heirs. 2. Malik invalidated Aisha's hadith where she said that of the verses of the Quran that were abrogated was that only 10 full breastfeeds make the infant a mahram of the woman, and then this was fully reduced to 5 full feedings. Malik, following Ali ibn Abi Talib and Ibn Abbas and Ibn Umar, among a few others, claimed that the prevailing habit is that any feeding at all leads to a prohibited degree of relationship by fosterage, without any distinction for the amount of feeding. Shafi'i and others, however, upheld this hadith and further substantiated their claim by other hadith that explained 1 or 2 quick sucklings did not establish a prohibition. Aisha ibn Mas'ud and Zubair are of the companions who held this belief.